Thank you very much. Xin chào, which Google says is hello, and Chao Boi Chiu, which Google says is good afternoon. I'm glad to be here this afternoon to speak to you about the Malaysian legal system. I have some slides, but I'm going to summarize the slides because of time. Ned mentioned the English common law system. And the reason why we are here today is because the Malaysian system of administration of justice is based on the English common law. We were a former colony. We attained independence in 1957. And so our laws are very much based on the English common law. And there are these sources of law. I just put it up there for you to also look at this, because this will also explain my colleagues who will be speaking after me and where they come from in terms of common law. For example, we've talked federal law. Federal law is the law that is passed by our parliament. And you will hear about the Companies Act later. And that's an example of federal law. Then there's state law, because ours is a system where you have a federal parliament and state parliaments, you can call them, but they're legislatures. And then, of course, our courts rely heavily on what we call unwritten law, but case law, common law cases. So it is very common in Malaysia for us to cite English cases. Our system is highly based on English cases and in English. Although our national language is Malay, Selamat Tengah Hari just now was in Malay, but we use English widely. And then there is Sharia law for the Muslim persons and customary laws. We have a written constitution, that's our supreme law. And again, the written constitution, the person who drafted a written constitution is a gentleman called Lord Reed, an English law lord. So that tells you where the common law influence came in. We have statutes like the Courts of Judicature Act, which governs our courts, rules of court procedure, and some of the statute laws that I've mentioned there. Now, why do I bring this up? I bring this up to tell you that we have a very established system in Malaysia. It actually goes back to the 18th century. That's how long it is, all right? And the system is highly, I repeat, based on the English common law system. So in all this, you'll see elements of English common law codified. That means in writing. Previously unwritten, now in writing. This is our hierarchy of our courts. The lowest courts, the subordinate courts, are the magistrates' court and sessions court. What we call as a superior courts, or the High Court, Court of Appeal, and Federal Court. They all have their own jurisdictions, monetary jurisdictions. It's in Ringgit Malaysia. The Malaysian Ringgit is shrinking badly these days. So if you take 100,000, divide by 5 US dollars, all right? Magistrates Court, that's the jurisdiction. Sessions Court is the next jurisdiction. Then comes the High Court, where most of us practice, because that's the high value claims, if you like. And then some of us here appear in the Court of Appeal, which is our first appellate court, and the Federal Court, which is the ultimate or the apex court. So what does this tell you again? We have an established system, court system, all right? Which a structured court system. And if you go and compare this, you'll see the same system in almost all common law jurisdictions. If you take the UK, if you take Hong Kong, the common law aspect of Hong Kong, you will see this is the kind of system you have. You take Singapore, this is the system that you have. It's all based on a common law philosophy of how the system administration of justice should be based. Then we also have this, and I only put this up so that I can complete the picture. For employment law, we have the industrial court and the labor court. I'll talk about that shortly later to explain how our employment law system works. This is the court process. You'll be very familiar with this. We have written documents, which are called written pleadings. We have applications before the trial, which are called interlocutory applications. There's a trial process. Judgments are written. Judges, after they decide, will write a judgment. They will explain why they came to the decision. And if you're not happy with it, you appeal. There's an appeal process. Written pleadings will set out in writing what your case is. So there's no surprises. If you have a case, it must be in writing. And if I have a defense, it'll be in writing. Applications are where you find, for example, the case is not good enough. It should be struck off. You shouldn't waste the time of the court. You'll file interlocutory application. If you want remedies to protect your rights, injunctions. I stop here. Again, what I'm saying to you is what you find in every common law jurisdiction. It's nothing new, all right? So we actually apply the common law in even our court process. The trial process, ours, Mr. Nat mentioned just now, is adversarial. It's an adversarial system. So you will have a full trial in court, 2 sides, open court. We believe in a system called open justice, which means our courts are accessible, open to anybody and everybody. When the court goes on, you can come and watch the court, the proceedings. Of course, these days we are mostly online, So it's a bit difficult to watch online, but we are based on an open court system. And judgments of the court, as I mentioned, are in writing. Then there's an appeal process. If you're not happy, it doesn't mean it ends there. You have at least 2 levels at any stage. At any stage, you have 2 levels of appeal. If it's the magistrate's court, it's a sessions court and the high court. If it starts from the high court, it's the high court, court of appeal, and the federal court. Again, yes, 2 appeals. All right? Yes, 2 appeals, but at some point, you may need to get permission, which we call leave. It's not automatic right. 1 appeal as of right. If you take the high court, court of appeal, and the federal court, 1 appeal from the high court or the court of appeal as of right. All right? After that, court of appeal to the federal court, you may get permission, which we call leave. Again, you see, if you remember that is actually the system that you have in the UK. If you want to appeal to the Supreme Court, you need to get permission. We call it leave, they call it permission. So the system is actually the same. Now, I want to emphasize this also because my colleagues will be speaking about this. We apply this principle called, well, it's a Latin word, stare decisis. It simply means a decision made by a superior court binds the lower court. So if the federal court makes a decision, all the courts in Malaysia must follow. And sometimes I was reminded by one of my colleagues just now when we were discussing it, the federal court makes a decision that could be wrong. We as lawyers could all say it is wrong. But no court below the federal court can say, well, because it's wrong, we are not going to follow it and you're going to ignore it. You can't. So it's called the principle of stare decisis, which is binding precedent. So we have a system of precedent. This is the English system as well. The English system is based on precedent. If a case is decided, that case will bind all the courts in the courts below, all right? And they must follow. My colleagues will talk about this more. The alternate dispute resolution, which is essentially arbitration, mediation, and adjudication. I won't get into that. That's also a system that we have, a parallel system, if you like, where you don't go to court. So if you don't go to court, you want to go for arbitration. We have an established system in Malaysia, and that will be spoken about. Let me get to this, which I think is a matter of interest. Labor law disputes. Now, labor law disputes are important because every investor that comes into Malaysia, sets up a company, will have to employ. All right, you'll have to employ. Whether you employ them physically on site or online, you have to employ. So it's important that you understand again that we have a very established employment law, labor law, dispute resolution system, which is also based on the common law, English common law. And we apply the English common law, all right? We have codified laws. These are the 3 main statutes. The Employment Act deals with your terms and conditions of employment, whether how much of leave you get, whether you can go on maternity leave, and so on and so forth. The Industrial Relations Act is very important. It's the single most used statute in Malaysia. Why? It deals with the termination of employees. If you sack an employee, it's dealt with under the Industrial Relations Act. Then you have the Trade Unions Act because we have trade unions. I think there are trade unions also in Vietnam. They are governed under the Trade Unions Act. Under the Industrial Relations Act, a very important concept. The concept is if somebody considers themselves to be dismissed, what we call without just cause or excuse. That means they don't accept it. They say, you have no reason to have dismissed me, all right? They can go to the industrial court. They can file an application within 60 days to the industrial court and have their claim heard in the industrial court. If they don't go within 60 days, they miss the 60 days and they're still unhappy about it, they can still go to the civil court. But in the civil court, you understand shortly, the remedy is very simple. It's only a notice period. But the industrial court is a very powerful court. It's the only court in the land that can actually reinstate an employee. In other words, you sack an employee, you don't like the employee, you lose your case, he comes back to work with you. I always say it's like a couple. They get divorced, and after that, the court decides, yes, you're divorced, but I'm putting you back in the same house. Please share the kitchen. All right? That's what happens. All right? So another concept here, very important. Many of us will see in employment contracts, your letters, it says, either party can terminate the contract of employment with giving notice, whether 2 weeks, 1 month, or so on. All right? That is always there. In Malaysia, the employee can terminate. The employee can say, I don't like you, I want to resign. No problem. Up to you. You can go. Freedom to leave. But the employer cannot give notice and sack an employee. If an employer wants to get rid of an employee, the employer must show just cause or excuse, which means a misconduct, poor performance, retrenchment. These are the broad areas, right? So when you, in a Malaysian, if you come to Malaysia and you have an employment contract, and if you say, I will hire you, I have a freedom to hire, and I have a freedom to fire. I'm sorry, you have a freedom to hire, but you do not have a freedom to fire. The freedom to fire is only if you can show just cause or excuse. I'm not sure whether that's a system that you have here. I'm sure you'll comment later. It's a very different system that we have. What is a misconduct? Actually, almost anything that breaches the employment contract. It could be something minor, as turning up late for work consistently. It could be something very serious, like committing fraud, stealing from the company. They're all misconducts. If it's a minor misconduct, you don't sack the employee. You can maybe impose a deduction or salary, demotion. Major misconduct, you will sack an employee. These are the kind of misconducts that we broadly have. If it is relating duty, it's dishonesty. Discipline is, for example, if you're fighting or gambling, and morality is all of those things that you have where your behavior is not something that is acceptable. So these are the kinds that we have. Then we have poor performance. Poor performance is not a misconduct, but if somebody is considered to not to be performing to the level of the expectation, they can also be sacked for that reason. But they can only be sacked after the employer gives them enough time to improve. If they do not improve within a time, then you can get rid of them. All right. Very difficult to prove, because what I consider to be poor performance and what the employee considers to be poor performance will be different. I may think the employee is a poor performer. Employee may think nothing wrong. The court may disagree and think that he has done nothing wrong. All right. Difficult to prove. Retrenchment, I think you know what that is. Essentially, when a company feels that we have too many employees, our business cannot sustain the employees, too many people doing the same thing, we need to get rid of some of the employees, they will retrench. This is a common law concept, constructive dismissal. What is constructive dismissal? Where the employer doesn't sack the employee, but the employer does certain things that causes the employee to say, look, I cannot work anymore, and he walks out. It's called constructive dismissal, all right? Some famous English cases have decided this, and we have applied that in our jurisdiction. I just want to end with this, because my time's up. I see a thank you. Thank you very much. I will end. I end by just saying this, what I said just now. If you lose in the industrial court, an employee goes to the industrial court in Malaysia, and this is what all investors must know. This is what you're going to face. If you lose in the industrial court, number one, the employee could be reinstated. That means he puts back where he was, with no loss of benefits. But if it cannot be reinstated, you are up to paying 24 months of the last drawn salary plus 1 month for every year of service, which is very hefty. The submission, I leave this to you because there are certain amendments to our laws recently, changes, you can read about it. But the long and short of it is simply this. In Malaysia, first point, easy to hire, difficult to fire. Second point, the courts are very much weighted in favor of the employee. So how do you deal with that? Well, you need to get good lawyers. I won't say who they are. Third point, all of this is based on a common law system. Our system is based on the English common law. So if you have an issue considering the English common law on employment law, any Malaysian lawyer can actually advise you because we apply the same system. Thank you very much for your attention. I'm happy to take any questions that you have. Thank you.
Thank you, Mr. Thiru. And you guys can realize that there are many similarity of the labor law compared between Vietnam and Malaysia.